Once we decide that a living trust is the right estate planning document to serve your needs, we need to make a decision on the type of trust to meet those needs. And there are many types of trust, but generally we look at 7 different types of trust here at the Anderson Law Firm. The first is our standard trust. For a single individual or for a married couple, this is the standard trust that you'll have in most situations. We have prepared thousands of estate plans here at the Anderson Law Firm, and at least 90% will be the standard trust variety. Basically, this is a trust contract that, if you're a single person, is for you during your lifetime, and then specifies a successor trustee to manage things upon your death and to distribute the way you've indicated you want things to be distributed. Or for a married couple with assets that are beneath the exemption for estate tax. That current exemption is for $5 million, and in the next years we don't know what Congress and the President might agree to. It may be eliminated, in which case the standard trust might be right for everyone, or they may decrease the exemption to $1 million, in which case if your estate's in excess of $1 million and you're married, we might want to consider one of these other trusts that are available. For example, an A and B trust. The A and B trust basically is set up so that on the death of either husband or wife, if your assets exceed the exemption from estate tax, we can split the trust into 2 trusts, A, or usually the survivor's trust, and B, the decedent's trust. By doing that, the survivor can do anything that they want with the survivor's trust, the A trust. The B trust, the surviving spouse can be the trustee or be in charge of it. They can get the income from all the assets that are funded to the B trust, but that trust has become irrevocable, so the beneficiaries and the terms of the trust cannot be altered. There are variations of the A and B trust to meet different needs, but that's the primary function, is to avoid or minimize the chance that there will be estate tax. On occasion, we also use this type of a trust when we have a situation where spouses are concerned that upon my death, my surviving spouse will remarry and now leave all of our assets to the new spouse, thus eliminating any inheritance to my children. So we will have the A and B trust so that my portion of the trust becomes irrevocable and will go to my children on my spouse's death. When we deal with estates that are well in excess of the exemption, we start considering what we call the ABC trust. It's just a variation on the AB trust for estates of larger size. Basically, once again, 1/2 of the assets will go in the A trust or survivor's side, and then the amount equal to the exemption for estate taxes will generally go into the B trust, which we sometimes call the bypass trust because it bypasses estate tax, or the exemption trust because it equals the amount of the exemption, with the balance of the decedent's share of things going in the C trust. We call those marital deduction or marital exemption assets, or even sometimes Q-tip because they're qualified terminal interest property assets that fund that trust. Sometimes we have people come in and there's someone in the family with special needs. This could be a young child born with Down syndrome. It could be someone that as a result of drug addictions now has problems. But in any event, they're receiving or someday may be entitled to receive governmental benefits such as SSI or Medi-Cal. These are needs-based benefits, and so an inheritance will disqualify the individual from receiving those benefits. So we need to examine closely how can we benefit that person and have them not lose the governmental benefit program that they're entitled to and need for their well-being. There are several ways to do that. Sometimes we exclude that person completely from the inheritance so they don't have too many assets and thus are disqualified. And other times we give an extra share to one of our beneficiaries and depend on them and trust them that they will do the things necessary to assist the individual that's entitled to governmental benefits. But the other option is the rather intricate and sophisticated Special Needs Trust. The Special Needs Trust limits substantially what we can use funds or assets for, but it's something to look into if we want to provide for an individual but not have them lose their governmental benefits. Almost every family has a ne'er-do-well in it. Someone with an addiction, someone who cannot handle monies, but we still want to provide for in a way that they don't end up out in the gutter. We call the provisions for them spendthrift provisions. We try to maintain the trust for them so that the assets that are set aside for them are not available for their creditors, and we provide for them in a way that they don't get all of their inheritance at once. Other trusts that we consider are the Irrevocable Life Insurance Trust, also called an ILIT. And the reason we consider that type of a trust is so that we can keep the benefits of a life insurance policy outside of our estate for estate tax consideration. So, if I have a life insurance trust with $1 million life insurance policy in it, if it's outside of my estate in this irrevocable life insurance trust, that $1 million is available whether to pay estate tax or for my beneficiaries. On the other hand, if I own that policy and it's a part of my estate, and my estate is large enough that there's an estate tax, $450,000 or so of that $1 million might go directly to the government. So if your estate is large enough, that's worth considering. The other consideration, if you have charitable giving in mind, are charitable trusts. Sometimes we take assets that we have that have appreciated in value, and rather than selling or liquidating those assets ourselves and paying the capital gain, we place those assets in an irrevocable charitable trust so that they'll go to the charity upon our death. We set the trust up so that we can have income each year during the course of our lifetime and maybe our spouse's lifetime as well. And then upon our death, the asset goes to the charity outright to use for their purposes. Typically, the charity will liquidate the asset that you give them, but they get to do it without paying income tax on it. So they get the benefit, we get the benefit of the full value of the asset. I hope this helps you decide what type of trust might be necessary for you so that when you sit down with your expert estate planning attorney, you'll have an idea of what he's going to discuss with you and what is right for you.